Good afternoon, everybody. My name is David King, and I'm a partner in the private client team at Harrison Clark Rickabees. I'm here today with my colleague Andrew Morris, a partner in the family team, and we've also got Marlon Pinto from AnotherDay, and we're going to be talking to you about your digital footprint. As part of my role in the private client team, I'm regularly approached by clients looking to put in place things like wills, power of attorney, and also looking at general estate planning matters. Now, in terms of digital assets, when we look at a person's digital footprint, those assets can take many forms. Now, historically, when clients would have been coming to see us, they would have most likely 10, 15, 20 years ago, it would have involved a work of art, potentially a piece of music that we would have been looking to protect copyright over potentially. But nowadays, we're seeing more and more things like betting accounts, Facebook accounts, iTunes, iCloud, all of these things that people potentially just take for granted and don't really realize that form part of their digital footprint. Now, for me, these are all crucial parts, potentially, not only because of their sentimental content, but in some cases their value, that need to be taken into account when we're looking at a person's estate planning matters, but also how people can access these accounts for them, not only when they've died, but also at a point in their lifetime where they may simply need some assistance. You know, we're seeing more and more people live to old age, whether that be in care homes or people that may suffer with a stroke or an illness that means that they actually need someone to sort of stand in their shoes and make decisions on their behalf. And dealing with their digital footprint is going to be a key part of that. Now, when we look at digital assets and take it back to its very basics, the digital asset is simply a sequence of noughts and ones that appear in any kind of particular order to denote what that digital asset is. Now, that may mean absolutely nothing to many of you. It may mean lots to some of you. However, I think if we take an iCloud account, for example, I think there'll be many people on this call that have got an iPhone. Ultimately, what can you do, or what can your executors following your death, what can your attorneys during your lifetime, if you need them to help you, do with your iCloud account? Now, the short answer is probably very little, potentially, or in some cases, that iCloud account could contain very valuable information. So it could allow access to email accounts, to music data, to photos, some of which may hold quite a lot of sentimental value, but in other cases, things like apps on your phone, if you've got a gambling account, for example, it's how do you actually get on and get the money out, get the photos out? Can you even do that is one of the questions that needs to be posed. These are all things that we draw out of people as part of that process of taking will instructions, taking instructions in connection with the drafting of powers of attorney. And also when it comes to some of those assets that have got an intrinsic monetary value, is looking at estate planning, which is something I'll come on to later on. Now, we need to draw a distinction between the personal possession itself, such as the laptop or the phone, and the information that's contained within those devices. So the literary works, for example, if you've got a job as an author, the music that may be on there, and the photos. So the two are treated very differently. The personal possessions, that's easy. So the personal possessions will pass to the people that you've designated under your will as the beneficiary of them, or your attorney will be able to access them, provided that they can. Again, this draws out the whole element of password, which again is something that I will come on to later. But with biometric and also traditional passwords being required in some cases, it's how do people access these devices first and foremost. Now, there are risks associated with sharing passwords. And one of those things that we get told to change every now and again when you're at work, and it's something that I think many of us don't change as frequently as we perhaps should in the real world. And I'm sure over the course of the past couple of weeks, you've heard lots about fraud, cybercrime, all of those things. And these are all very relevant points that as private individuals, you need to consider in connection with your personal affairs, and not only from a business standpoint as well. Go back to the iCloud account. In actual fact, when you ticked that little box that flashed up in front of your eyes to say, did you agree to these terms and conditions, you may or may not have been aware that you're actually signing up to something under Californian law. Now, as much as I'd love to be in California right now, and sunny Cardiff will have to do for today, did I intend to be bound by Californian law when I ticked that little box to sign up for my iCloud account? Probably not. Did I even realize I was doing that? Well, because of the role that I'm in and because of the job that I do, I did, but I probably didn't think too much about it when I did it. Now, what does that mean? In effect, following your death, or in some respects during your lifetime, if people have to access those email accounts, they're going to have to deal with Californian law. With all due respect, It's not something I can advise on. I'm not qualified in California, and quite honestly, I didn't realise the ramifications of what I was doing when I signed up to it. So, we had a case recently where a client has spent lots of money on music. So they've got this huge iTunes account with thousands and thousands of songs on it, but in actual fact, following their death, all of that music was lost because those accounts are non-transferable. The family didn't realise that, and this was something that had sort of come to light at, as I say, following death, which had caused lots of sort of heartache for the family, really, because it was seen as their record collection. Traditionally you'd have the vinyl in the drawer, but this was their digital footprint, effectively. It was the way that the family would have remembered them. Now that was quite a sad case, but we've all heard of the stories of people losing storage devices with crypto keys on that you end up throwing away £250,000 to the Bitcoin, for example. Now, thankfully, those instances are few and far between, but even still, the issue of sort of understanding exactly what a person owns, what their digital footprint looks like, and then coming on to the fact of how you access it and how you can deal with that following a person's death, or in the event that they were to lose capacity. These are all key considerations that have to be talked through in individual cases. Now, if we sort of look at the two different roles, so you've got the role of executor when someone's died through a will, and you've got the role of an attorney through someone's power of attorney. So that's the situation whereby you're still alive, but you need something doing on your behalf. Now, those two roles and the choice of who you appoint in those roles, for me, is absolutely crucial. So what you don't want is someone in a position where they don't understand, or perhaps they won't be able to deal with your digital footprint in the way that you would have wanted them to. Now, again, I don't know whether this is a sign of the lockdown that many of us, well, we've all been through, I should say, over the course of the past 20 months. Bitcoin, cryptocurrencies have been the talk of the street on our doorsteps over the course of the past few months, and whether that's people just being with a bit of bravado saying that they've got X amount of Bitcoin or not, time will tell. But I think more and more people seem to be having this type of asset, but do they actually understand the ramifications of doing that? So it's all well and good holding the assets, but who's actually going to access it? Who are you entrusting with the ability to deal with those assets, either during your lifetime or on your death? Now, with the whole access point comes security issues. So, allowing people access to these assets, giving over certain data. So whether that be your user ID, for example, your password, you could actually find yourself in breach of the commercial agreements that you sign up to by handing over your password to these accounts. So, I know for a fact that under the iCloud accounts, if you actually read the terms and conditions, you're not allowed to give out your password. And in theory, you're in breach of the law when you do that. Now, realistically, I'm sure there've been instances where many people have had to do that and they've not thought anything of it. But these are all things that people need to take into consideration as part of this process.
Quite interesting, you talking about sort of the passwords and the contracts that you're likely to breach by passing on. But how do you keep all this information secure? I mean, it's ever changing. Sort of, what tips do you have that people can try and help the people who are meant to be administering their estate?
That's a really good question, Andrew. I kind of wish I had the answer, because I think I'd be a very rich man. But unfortunately, I think with all of these things, it's an ever-evolving playing field. The whole idea of cryptocurrencies is relatively new still. When we look at it, even compared to the internet. When we look at the time difference between the internet first arriving to cryptocurrencies arriving, my view is they're still in their infancy. Now, I am aware that there are a number of providers out there that will provide insurance, so against things like losing your access key. So again, products like that can provide some security. There's cold storage. There are all sorts of other storage methods to be able to store your access keys for these crypto-based currencies. They come with a cost, but I think given the value at which these assets are currently sort of trading on the markets now, I think it's certainly worthwhile, if you do have concerns around sort of access and protecting people's ability to access those assets, looking into things like cold storage, insurance products. It's really difficult. So us as solicitors, for example, we'd be in breach of our own insurance policies if we were to hold things like password data on file notes, because it just opens up clients to risk. I've touched on it there in terms of the value of these assets as well, and it kind of ties in really with looking at wider, a person's estate planning as a wider field. So, the will, power of attorney, all forms part of that estate planning piece. Now, estate planning for me covers a number of things, but the main part of what people want to discuss when they come in and see us is how do I avoid inheritance tax? And I think people have to start looking at these digital assets and realize that they come with an intrinsic value. Bitcoin, for example, the price goes up and down by the minute in the same vein that share prices do. But I think looking back 5-6 years, would you ever have envisaged that the price of Bitcoin would be where it is today? We see clients in who've got varying degrees of holding, not just in Bitcoin, other cryptocurrencies. Some of whom are doing very well for themselves, others who potentially invested at the wrong time and the value has gone down. But at the end of the day, you have to look at those assets as tangible assets that will form part of your estate for tax purposes. Now, that's not only on death, it's also during your lifetime. So if you sell these assets, if you're receiving an income from them, then there will be tax consequences that flow from that. And that's something that people need to take into consideration. Now, what in terms of what people are doing, it's almost treating those cryptocurrency type assets as they would a property or stocks and shares or cash in the bank. So it's looking at those assets and thinking, okay, am I going to put assets into trust? Am I going to give them away? These are all things that people can do with cryptocurrencies. It's just all about taking some proper advice from ourselves and from financial bods as well, just to make sure that what you're doing is in your best interest ultimately. One area where again we've seen a lot of interest, I suppose, has been with betting accounts. Now I don't know whether it's been on the back of the Euros that sort of this has come about, but we've seen a number of people approach us recently with questions about betting accounts. Now I suppose that those questions have been twofold. One, in terms of people potentially not realizing that their other halves have had betting accounts for many reasons, which I'm sure Andrew will come on to on a matrimonial standpoint. But funds can accrue quite easily in these accounts, and you don't quite realize the monetary value that can be attached to something. And just to kind of link that back, it all ties in with one, knowing that the accounts are there, two, being able to access it, and three, having the relevant authority to take the money out. Because accounts like this, albeit it's come from a windfall that people have had, there's still assets in the person's estate. And if you are, for example, appointed as someone's attorney and that money is built up in that account, it could be really important that you can get that money out to help support their costs of care, for example. So having the proper and appropriate documentation in place with the relevant instructions and authorities written within the document to enable you to deal with these types of assets is crucial.
Dave, you make the point about the fluctuating value and the fact that people could make a significant profit on their Bitcoin. I assume that means that not only are you going to look at having to pay IHT tax, you're probably paying capital gains tax like any other investments on Bitcoins.
Correct. Yep. So that there are income tax, capital gains tax consequences for holding these investments. Ultimately, when they're sold, at the end of the day, proper tax advice should be taken before entering into any transactions of that nature. I think depending on, I suppose, how frequently people trade in these markets, whether it's something that was just a bit of a one-off, or whether people are dedicated traders in the market, will all lead to them having different understandings in terms of what they need to report and what they don't. So I'd hate to think that people fall foul of the relevant requirements. It may potentially lead to them needing to file tax returns, for example, where they might otherwise think that they need to. Look, we can certainly give people a steer in the right direction.
With the ever-changing technology, more and more people are investing by themselves without having to go through the normal sort of stockbroker approach to investing. They can do it on their phone or on their laptop. And so there's a lot of information there, and I suppose a lot of items such as their phones and laptops where they could have all this information.
Exactly, and I think it's, I've kind of made the point already, but I think it's sort of knowing what's there. When a client comes in a decision, we take a very detailed fact find in terms of what assets that person's got, and that includes things like online accounts. Now, again, we would never take password information from people, but at least if we've got a starting point to know this person had X, Y, and Z financial accounts, whatever they may be, whether it's cryptocurrency trading, whether it's online gambling, whether it's X, Y, or Z. We kind of capture that information, so at least their executors, their attorneys have got a starting point to know where they need to look for these things.
That actually leads in neatly to what I'm going to talk about, because one of those key issues is trying to track down the digital footprints and this information when you don't necessarily have it. And a thought has just occurred to me that if someone's preparing their will, then they're likely to disclose far more financial information to you than they would necessarily to other people. So when I talk about how we track down these assets, it occurs to me that one of those questions is to raise whether they've got a will and try and get the information that they provided to their solicitor for preparing that will.
Completely agree.
I'm Andrew Morris. I'm a partner in the family team at the Cheltenham office here. And what I deal with is primarily divorce, resolving the finances on divorce, and also I do children matters. A lot of what Dave has talked about are the sorts of questions we have to ask ourselves, because when you decide to put a will together, or if someone dies, the first thing you need to do is to try and establish what there is. And that's the same thing that happens if you're in the unfortunate position where you have to consider getting divorced. The first step is to try and establish what the assets are, so that we can then look at how they are to be divided and who owns them. So within the court process, there is a principle of full and frank financial disclosure. So you're meant to provide all the information on any assets that you own, be it in your sole name or joint names, or via companies that you might own, and provide all that information. And you also are required to provide documentary evidence of that information so that people can see, for example, 12 months bank statements. It's interesting with Bitcoins and this cryptocurrency, it is fast moving. And I happen to look at the standard form that the courts provide us. It's called a Form E, a financial disclosure document. And it doesn't have anywhere within that document to say what you put down for cryptocurrencies. So to a certain extent, you sort of put it in the any other asset group. But it just goes to show, how quickly this is all moving. There are a lot of people now who have the ability to invest in cryptocurrencies without being a professional trader. And that information is not necessarily always easy to locate. Now, from the reason why it's relevant is taking just a look at the broad principles of what the courts would look at and what we try to do when we're looking at a divorce and dividing the assets, is the starting point is an equal division of everything built up during the marriage. And so that doesn't matter whether it is in your sole name or in joint names or in your husband or wife's name. It's all that information, including any interest in companies, any interest in trusts that you might have. All that information needs to be brought in. It is relatively easy in terms of trying to track down financial information when you're looking at more traditional items. You made the point about sort of someone's record collection. It's easy if you see that someone has a piece of art which could be worth a significant amount of money. Because you see there, it's physical, it's tangible. And of course, some people have questioned, it's not that long ago where the question was posed to the courts, well, are cryptocurrencies assets? They're very visible, because they're not tangible, they're intangible. And it's been found they are like assets, like any other asset that you would have. But that is a relatively recent analysis in terms of case law. So we're all trying to catch up very quickly, and sometimes the law is quite a long way behind.
I suppose jurisdictionally, Andrew, as well, I mentioned that people can inadvertently end up signing documents that relate to foreign legislation. How does that sit with the family courts in the UK now, if people have got assets that are situated in other countries?
The courts, and the English courts specifically, are pretty good at dealing with assets in other jurisdictions. But there are some obviously practical legal elements that if an English court was to try and make an order against some property, bricks and mortar within another jurisdiction, it's all well and good the court making that order in England and Wales, but there becomes another question as to how you go about enforcing that in another jurisdiction. The problem with cryptocurrencies is really where it is located is basically on the principle of who has that private key. And that can be transferred across the world in a matter of seconds. And the exchange isn't really a way of identifying where it is being traded. It's not like it's traded on the London Stock Exchange. You know, it's traded within a cryptocurrency platform, of which there are many, but that doesn't provide you with a location. So I think what you will find with the English courts and the judges is that they'll be very pragmatic about it. And they'll say, okay, if we can establish that there is a cryptocurrency that might be worth £100,000, we're not entirely sure in which jurisdiction, where we'll put that into the balance sheet and the asset sheet, and we will give you the equivalent of £100,000 in bricks and mortar in the jurisdiction that we know that we can deal with enforcement orders against. So you might get a greater share of the property within the UK or the bank accounts within the UK.
From a valuation perspective, I know if we're valuing these things at the date of death, that there's a trigger date, which technically is the date of death, that, you know, on which you can kind of freeze the value of the asset. How does that work from a divorce angle? Because, you know, the fluency with which these currencies kind of fluctuate in market value, it must prove difficult.
Well, it does prove difficult. The key principle is the point at which you're asking the court to make a decision is the date that you are valuing the asset. But of course, if you're preparing to be in a courtroom before a judge and asking a judge to make a decision, that information ready for him to make a decision is gathered sort of weeks in advance. In the world of Bitcoin, that could make a massive difference. So ultimately, what you're going to have to do is to pick a strike date and say that is the date that we are going to agree that this asset is worth £100,000. And it ultimately means that if you then get to the court date and it is changed significantly, well, the court's approach is likely to say, well, this is the risk you take. It could have easily gone up as well as down. And there are cases where, for example, the 2008 financial crash, where there was a husband who took his share of the assets in shares. And not long after that, the crash effectively made those shares worthless. And he went back to court to say, hang on, I'd like you to set aside this order, judge, because circumstances have changed and it wasn't foreseeable. And the judge effectively said, well, it was foreseeable. You were happy to take on that asset rather than distributing the risk, so you all shared in it equally, because you thought it was probably going to be worth more in the future. And you made that business decision. And as we both know, business decisions can be good as well as bad.
Yeah.
Bad business decision. But the problem you have with Bitcoins, and it's something that you have touched upon, is you need to have that information first to start off before you know where to look. Because if you don't have a knowledge that your other half is trading within Bitcoins and you don't know where they trade or how they do it, it's very difficult for us to try and ask the right questions to predict where that information is. Especially if you believe the situation where there's going to be an element of distrust, that person is going to say, I don't have any Bitcoins. You will then have to be able to persuade a court that either they may potentially have them or that they do have them. The starting block is trying to show a court that you might have the merits to ask for some preliminary disclosure orders to be able to go out and find that information. And the courts do have powers of disclosure orders and freezing orders where they can make orders against third parties to prevent them from transferring a cryptocurrency. You can also have orders where you can ask them to disclose that information and secure those physical elements. You made reference to the cold storage, for example. Well, as you say, that there are cryptocurrencies which are traded, and to some extent you can locate that through a reasonable amount of investigation, but there are also ways of holding these perfectly legitimately ways in cold storage, USB sticks, computers. So you will need to make applications for orders to be able to have that secure that cold storage, that physical element, in order to ensure that it's not transferred, because it can be transferred incredibly quickly. And that's the problem. Making disclosure orders or freezing orders against individuals, it's not the same as a bank, for example, where you can serve your order on the bank. You need to know who you're securing. And there's even been debate about freezing orders against unknown people, third parties, so that you can at least give them knowledge. If they have knowledge of it existing, then you can prove that they breached the order.
Okay.
In some circumstances, this can be a race across multi-jurisdictions. But of course, that's in the really sort of big multi-million pounds cases. In our cases, Bitcoins are still likely to be relevant and are becoming more and more relevant. And it's also relevant that people might still want to conceal that information. For whatever reasons, they may feel that there's a distrust, and that they feel is a morally right decision to take. So what do we do in terms of the traditional building blocks in being able to find that information? Well, the full and frank financial disclosure means you can start off with 12 months bank statement. So what you start to do by analysing those bank statements is you're starting to look up not necessarily what's there, but what's missing. Because you have the financial information of what someone earns, what you think that their spending trajectory is, because we still utilise bank accounts and credit card statements. And you can get disclosure of that information from the court. And you start looking at that information, and it is effectively a double entry bookkeeping exercise. It's a paper trail. You follow the money. There are many examples, and you would have read them in the news, where you have people turning up to court saying, I don't own anything. I have no assets, Judge. And then the cases there where they're living a multi-millionaire's lifestyle. That's where you start. You start by saying, well, what am I expecting to see? What sort of expenditure? If you know that someone has posted an Instagram shot of them on holiday on a Caribbean island, you'll be looking for the flights. You're looking for some spending in the airport. All these bits of information you're expecting. And if it's not there, then you start to raise questions about, well, how is that being spent? Because unless you're incredibly sophisticated, the buying of those Bitcoins has to start somewhere. And that has to start in some cold hard cash, or you're actually mining them yourself. And from my understanding, that is quite a serious endeavor now, because it becomes harder and harder to mine Bitcoin as less and less Bitcoins are put on the market. I think I read somewhere that the overall trajectory of how many Bitcoins there should be out in the market is something like 21 million, and they're at 88.5%. And so it's becoming harder and harder to mine Bitcoins. But there are traditional methods that we can use to try and track that information down. And that's what we look to do. And once we've had that information, we can agree a value, then the court can decide how it can be divided. And you don't necessarily have to take the Bitcoin. You can have that offset against another asset. But the key element of this is information, and knowing that you have that information, so you knowing where to look. You talked about people's iPhone, iTunes accounts, and it's an interesting point. I hadn't really thought about the value of someone's iTunes account, because insofar as I said, a piece of art could be a valuable item taken into account on divorce. One would say that someone's vinyl record collection that could be worth £10,000 is of value. When you pose the question, at what point are iTunes accounts going to have the same value? With iTunes, you often find that people mix and match their access to iTunes and Spotify. And people's iPhones and iPads are all linked. And I have seen on a regular basis that when times are good, you're happy to share this information and share your ability to use your different digital platforms and different apps. But as the situation deteriorates, you tend to look to be more private and have your information kept private. And there does become a point where your information is private. And it's all well and good saying, well, I'm your husband, your wife, we share all that information. And that's absolutely fine and correct. But there comes a point where you are talking about separating or divorcing. Well, that information ceases to be transferable. You can keep that private. But what you have to be sure about is if you want to keep information private, is that you need to make sure that you're changing your passwords. You also need to make sure that you're unlinking your iPhones and iPads. The number of cases I've had where people have had private information disclosed to their other half, all third parties, because they had forgotten that their iPhone is connected to the iPad or to the iMac, and those emails have been disclosed. And it can be, financial information. It can also be private advice that you're obtaining from your lawyer if you're contemplating the possibility of a divorce. So it is important to think about your digital footprint and who has access to it and how you keep that secure.
In terms of that digital footprint, Andrew, I suppose I see digital assets as sort of a more modern thing, and with that comes things like prenups, postnups. Are you seeing an uptake in people, I suppose, of a younger generation perhaps that are investing? I'm not saying cryptocurrencies are just something for the younger generation, but I think typically the people I'm coming across are that younger generation that are involved in this market. Are you seeing them more aware of the need for planning against things like divorce through prenups, postnups, and what steps can be taken there?
Yes, it sort of starts with a more traditional element where people are far more likely, because of the pressures on housing, to have received support from their parents to purchase their first property. Mm. I'm seeing more and more people who are coming through the door to say, look, I'm going to start living with my boyfriend, or I'm living with my girlfriend, and I own this property, and I'm a bit concerned about what happens if we were to separate? Are they going to gain an interest? And so I've seen a lot more inquiries on cohabitation agreements. And that's something which is almost, it's the starting point. It's the building blocks to establishing, right, how are we going to share our life together and share our finances in whatever we can. Within the world of divorce and family law, the courts don't just look at the date of which you get married to say how long you've been married, which has an impact on how they divide assets. They'll look at the whole course of the relationship. So if you've been living together for 10 years and then get married and then divorce after 5 years, it's not a 5-year marriage. As far as the court is concerned, it's a 15-year marriage. And if you think about all the financial decisions that you make together during the course of those 15 years, whether or not you are married, that has an impact on people's circumstances and their needs. Mm. So often, you will see people talking about entering into cohabitation agreements and then getting married and entering into a prenuptial agreement. And I think the next generation is more relaxed about that. I think they're more familiar with the idea that there is going to be a certain degree of financial independence. And more and more couples are working couples. They have to be. And so they come in a more equal status. And where there are these circumstances, there are legitimate reasons for cohabitation agreements and prenuptial agreements. Yeah, people have been a bit more open at the start. That's for sure. And are happier to enter into agreements to regulate it. Okay. So what I was going to do now was introduce you to Marlon Pinto from AnotherDay, because we've obviously been talking about as lawyers as to how we gather that information and how we utilize it. But there is another element when it comes to trying to track down these assets when people may not be as full and frank as you might hope them to be. And that's when you might need to instruct an expert to help. And Marlon Pinto from AnotherDay, that's what they do. They investigate and they help to track down crypto assets. So I'm now going to pass you on to Marlon, who's going to give a presentation about what their company does and how they go about tracking down this information.
Afternoon. Thank you, Andrew. My name is Marlon Pinto, and I'm the Director of Investigations at AnotherDay. AnotherDay is a security, intelligence, and investigations consultancy based in London, UK, and the Middle East. And some of the work we do includes supporting intelligence, regularly conduct enhanced country risk assessments, enhanced due diligence, and specific and complex assistance for litigation. Strategic planning, so we help with crisis, risk, and resilience planning to reduce risk and to ensure contingencies are in place. And we also provide capacity to support operations globally, such as working on the ground with major charities in conflict-ridden areas. We also conduct response to criminality. So some of the examples of investigations are investigations into whistleblowing allegations, international asset tracing, corporate investigations, and investigation support private prosecutions. Today, however, I'm going to talk about the fundamentals on crypto investigations and how it is put into practice. This presentation is more of an educational piece, so you can walk away with enough knowledge to understand how we, as investigators, track and trace crypto assets that will ultimately lead to an international freezing order against the wallets associated with the crypto assets and their recovery, or even as an initial asset tracing exercise to understand whether additional litigation support is viable for you or your client. In this next slide, we're going to start with the tracking and tracing. I want you to visualize the blockchain. Ultimately, these are transactions between wallets, and to identify owners, we look to identify movement towards what I refer to as the fiat currency edge. This is where digital assets such as Bitcoins and Ethereum are potentially exchanged into fiat currency such as pounds and dollars. The next slide here, we can see that same diagram, but I've highlighted the fiat currency edge, which is the red perimeter around it. Ultimately, we want to use this edge to find opportunities that will assist us identify the owners and controllers of those private wallets. These could be vendors, exchanges such as Binance and Coinbase, which I'm sure you know, or local Bitcoins, which is like a trading platform that allows users to sell off their digital assets, allowing peer-to-peer exchanges of a digital currency. So on this next slide, we're going to talk about how we actually track and trace. We use specialist platforms that allows us access to over 150 million crypto wallet addresses and scans over 1,000 open and darknet forums. This allows us to understand the nature of the wallets and identify illicit activity, i.e. are they trading on the darknet market or funding terrorism or making ransomware demands? What is not possible though by using this software? We cannot identify owners of those private wallets, but using the system can help provide you with the correct information that will help write applications for freezing orders. It's not possible to analyze blockchain projects such as token contracts. Whilst the blockchain has many, many uses I'm sure you're aware of, it can only be used to track and trace cryptocurrency and not token contracts. Also, any analytical work cannot yet be done by artificial intelligence and requires human interaction. It's not possible to trace through exchanges and services such as crypto ATMs. We get no meaningful intelligence by tracing through an exchange or a service. Ongoing transactions are often requested by the users. By this, I mean that the account holder who has signed up to services such as Binance and Coinbase are the ones that apply for those transactions, and then it's then processed by that service. With service infrastructures, a single output payment will have many individual addresses making it difficult to trace once it reaches that platform. What this means is that if everyone here watching this now signs up to Binance, it is possible that you will all share the same wallet address. Tracing through private wallets, however, does allow you to gather intelligence on who may control the private keys. For example, the services I mentioned, such as Coinbase and Binance, may hold the private keys for anyone that owns a Coinbase or Binance account. Also, some owners of these wallets will tend to know who they are sending and receiving funds from. On this next slide, I want you to visualize the blockchain and how this is how generally the public visualize the blockchain. It's a number of letters, numbers. These all make up the addresses, the transaction hashes, and the amounts that have been sent across. It can appear very confusing, and placing this in front of a judge in the High Court would, from my experience, cause a lot of confusion. So it is our job as specialist investigators to simplify this in a way that can be understood by anyone who's not familiar with the blockchain and cryptocurrency. I've highlighted on this slide the transaction hash, and I'll refer to this later on why this is particularly important. This is how we, as investigators, visualize the blockchain. You can see it's a lot more simpler. We use the software and we map out the transactions in a visual format. You can see that it's simple to follow with the start of the transaction shown in the yellow dots and all the relevant transactions coming out from it. Again, I've highlighted the fiat currency edge, as you can now start to see the importance of identifying this edge and quickly identify opportunities to apply for data such as KYC information. This will give you granular details such as the transaction hashes, counterparties that are involved, list transfers, and also any open source intelligence. As I mentioned, this platform allows access to a large amount of open and closed source data, and this is also shared with law enforcement agencies and government agencies globally. I'm now going to quickly touch on the most common obfuscation techniques that we come across. The first one is called peeling. This is where users will use specialist software such as Electrum to ensure that any change they get is sent to an address that they also control. In this example, you can see that they send funds to SendWire, an exchange service, and then direct their change to another address that the user also controls. This way, they're able to withdraw funds little at a time, but staying in control of the change that they receive. So in essence, they're able to peel away an amount at a time, but still get the change back. This next slide, we're going to look at hopping. This is where suspects try to create as many hops away from the exchange with the hope that the origin cannot be traced. You may see 1 or 2 hops, you may see 1,000 hops. The hops are essentially intermediary wallet addresses that the digital assets are sent to. This is shown by the black dots on this diagram. In this example, and on the top, you can see we have 3 hops, which happen within minutes of each other, which helps us as investigators confirm beyond reasonable doubt that the person who had made these transactions is the same person or entity, and that they control the assets throughout. Once it hits an exchange service such as Binance, that is where we're provided with the opportunity to apply for information from them and identify who potentially has control of those wallets. Mixing services. The easy way to visualize this is by imagining everyone watching this puts a solid gold coin into a bucket. And imagine that gold coin as a Bitcoin. The bucket is mixed around with a large spoon and you take a solid gold coin out. The chances that you take your coin out is not impossible, but then it's very hard to prove that it is yours. This next slide talks about the potential options. So at AnotherDay, we collate all of the material and investigate all of our investigations to a criminal standard unless otherwise stated. This is solely because the disclosure obligations in the UK are much, much higher than anywhere else. So what are your potential options? We could liaise with law enforcement. You can complete your case file for you and provide it to law enforcement for them to take over. Provide you with sufficient information to apply for disclosure and freezing orders, and subsequently launch potential asset tracing exercises. We can provide you with sufficient detail to litigate against other parties in a civil matter. Or the third option and final option is to launch a private prosecution against a suspect if you have been a victim of a crime. So putting all of this into practice, the next couple of slides, we're going to look at the case study of Iron Science versus Persons Unknown. This case follows on from the fundamentals that I've just talked about. So with a bit of background about this case, following various conversations with Marlon Black, Duncan Johns, who was our client at the time, agreed to make a number of investments into Diamond Coins, Uvexo and Orlean. All 3 were supposed to be initial coin offerings referred to as ICOs, which are similar in nature to initial public offerings. During the course of 4 months, Marlon Black had gained the trust of Duncan Johns via telephone calls and emails, and this resulted in Bitcoin transfers as ICO investments into Uvexo and Orlean. The total amount that was invested was over £568,000. So what did we do? We completed the blockchain tracking and analysis and reporting of those transactions, gathered, scheduled, and reviewed traditional forms of evidence such as emails, call logs, and bank statements to corroborate the allegations that had been made. If we now move on to the next slide, you can see here on the left is an image of 2 photographs sent to Duncan Johns from who he was led to believe to be Marlon Black. Marlon Black also had a strong Dutch accent. Immediately you're able to see that the top photograph is not the same as the person below. After completing some open source research, we identified that the lower image was actually an American blogger. And she had a very, very strong American accent. This was used evidentially, and we secured this as part of our package. This slide is a list of the transactions with the transaction hashes and the amount sent. As I previously mentioned, this is great, but also confusing at the same time. And it would be much better if we were able to analyze this and detail our findings in a very clear and visual format. So moving on to the next slide, that's exactly what we did. This diagram shows our analysis of each of those transactions. If you follow off on the left, the first set of black dots are the addresses that were listed on the previous slide. What we have done is trace the assets through the blockchain and through intermediary wallets to identify opportunities where the assets meet that fiat currency edge. These are highlighted by being boxed. And on this occasion, we can see that the funds were sent to exchange services, Kraken and Binance. To support any court applications, we analysed the wallets and looked for any illicit activity that have transferred through them. This simply shows the courts, or those who are subject to this report, that the addresses aren't actually as innocent as perhaps they have may initially been perceived. The next slide here shows the endpoints going into the exchanges. You will recall that I talked about a transaction hash. Any application made to a court or exchange service will require the transaction hash to isolate and identify the transactions that is subject to your investigation. So on to the next slide. And from my experience and on this case, the below was a list of things that the judge wanted to be detailed within my expert report. These were my introduction, my role, the factual background, the key concepts and terminology, key outcomes, the key transactions, and the obfuscation techniques and the required disclosure. Just moving on then, so what was the result in this case? It was believed to be this was the first ICO fraud case to go before the commercial court. It was one of the only cases where the court has granted permission to serve a freestanding banker's trust order out of jurisdiction against a cryptocurrency exchange. And this was the first time that the court had considered the lex situs of Bitcoin, so the location of Bitcoin. We also identified and froze $640,000 in an attributed wallet address in Kraken and identified entities linked to the fraudsters. Thank you. I hope you found this informative and you're able to take something away from it. If you have any other questions, please, my email is there in front of you. But for the meantime, thank you, and I'll pass it back over.